request Dr. Sushil sir to formally welcome our director sir and chairman of this program. This training program has been sponsored by UP Council of Science and Technology to create awareness regarding ITR and its management. So the mandate of this training program was to create awareness among scientists of the different institutes of ICAR, state agriculture universities, other universities, and postgraduate students and graduate students. So we have got around 234 participants which are applying for this training program. Due to limited space, we only accommodate physically 125 participants, and I am happy to inform you that we are broadcasting this program on YouTube Live, and around 109 participants what we have selected, they are watching this on online apart from the others, and we have decided that we will be giving certificates to these 109 participants also, which are joining this workshop online. About this participants profiles, participants are from 24 different universities of or institutes belonging to 11 states, UP, Uttarakhand, Rajasthan, Delhi, Madhya Pradesh, Bihar, Haryana, Assam, West Bengal, Nagaland, and Odisha. About the profiles, 77 are scientists, 7 are senior scientists, 11 are principal scientists, 15 are assistant professors, associate professors 4 and professor 3, technical officer 1, ICAR 11, postgraduate student 90 and graduate student 34. About the profile of these participants, 77 are PhD holders, 78 are postgraduates, and 79 are graduates. Sir, in this training program, we have arranged 4 lectures, sir. This Shavi, she is from Indian Patent Office, sir. She will be explaining about the patent, what is general introduction about the patent, and what is the Indian law about the patent, and other things she will touch. After that, sir, Miss Vidisha, she is coming on his way to this institute. She will be touching on, sir, drafting of the patent, this specification. This is most important for any patent to be granted. So she will be touching that. After any patent is granted, it is very important that technology should be transferred or evaluated properly. So sir will be touching, Mr. Rajnish K. Sharma will be touching about the technology evaluation and transfer of the technology. And after that, we will be doing an exercise for this prior art search. In the meantime, you will be knowing that what is prior art, and we will be doing that exercise, and I will be doing that exercise. And after that, we will be having the feedback form, and we will be distributing, sir, certificate to all the participants through online only, sir. They will get the respective certificate in their mail ID. This is all about this workshop, and I request you sincerely that you please, these experts has come from a long way, from sparing their time, and you please attend this workshop. So I think it will be beneficial for you. Now I request our director sir to formally welcome all the guests and also give his blessing to start this training program. Thank you.
So the dignitaries on the dais and all the participants in the hall, and all our Dr. Rajnish Sharmaji, Madam Surbhi-ICAR-CIRC, and all the our faculty, head of the departments, scientists, and the faculties from outside places, students, RS, SRFs, and all the participants. It's a great pleasure for me to welcome you all to this one-day program. And we are all scientists, whether it is scientists, professors, or research scholars. We are all scientists. So when a scientist is working in his area of domain, he will always want that his work gets a lot of visibility. So there was time before when we did not know much, that okay, we do something, we publish, and subsequently after publishing, we keep it hiding and ultimately perishes. So the buzzword of today is, if you do not publish, you do not bring this either in the form of a publication or a patent or a product or any kind of rights and other things, then you perish. So the buzzword is either you publish or you perish. So whatever little we do, it has a definite significance. So now the government of India is trying very hard that this country is doing marvelous in terms of science in every area, right from space research to hardcore physics to hardcore biology, which includes all areas of domain, basic sciences, agricultural sciences, animal sciences, engineering and technologies. So we have seen that especially when you talk of the patents, all those things everybody ought to know that what is patent and everything. But our main purpose is just to make us aware. Many of us also know that we have to, when you work in a particular area, I have to have the intellectual property rights and this has to be protected. But even if we are at the fag end of our career, still we do not know what are the various ways to protect your intellectual property. So every time there is need for an awareness about various updates and development in the areas of intellectual property rights. So although we have in ICAR, Indian Council of Agricultural Research, already we have intellectual property rights departments which are exclusively dealing and doing awareness, but still we attracted this fund from UP, Society, yeah, UP Council of Technology, just to make you aware of all the people who are working in the state of Uttar Pradesh. Along with, at the same time, I made it sure whatever opportunities and whatever experience we gain, we should share with all the people who are interested online. That's why I have been telling that whatever activities are going on in this institute, it must be spread throughout India, even to the world. So we may look small, but our thinking, our vision are very much broad enough to share to the world community. Coming to the IPR, I am not going to define and other things. I am just going through. India ranks 42nd among 55 leading global economies on the International Intellectual Property Index 2023 released by the US Chamber of Commerce. So according to which India is right to become a leader of emerging markets seeking to transform their economy through IP-driven innovation. UC at the top, followed by US at the top, followed by UK. You see, UK is such a small country. That means they are doing quality research where they are protecting their intellectual property. If we are comparing to China, China is much ahead of us. Our position is 42nd. And as economy, if you see, India is going to be a third largest economy in a couple of years. That way our position should be third in the IPR list. UK, such a small country, is coming second. So you should believe in quality research. If you are doing quality research, then ultimately whatever product that will come out with the quality. But the only thing is we should know actually how to protect our quality in terms of protecting its intellectual properties. Rights and other things, those will be covered. What are the things which are covered under the intellectual property? And knowingly, we have kept this program a very low key affair. We believe in substance rather than making others happy. So whatever little we do, let us give more time for more discussion, and you see the program that has been designed, only few lectures, 1, 2, 3 and 4 lectures are there, and there is plenty of time for discussion. So right from a very young student till very senior level scientists like us, always we are eager to ask others, I have this, whether I can apply for a patent or not. So with so much of doubts, every time there need to be a lot of, you should be clear of your doubt, and even if you can give your thoughts can be patentable, your ideas can be patentable. So there are many different ways how it can be done, and when you are submitting a patent, filing a patent, protecting your rights, you have to make sure how much is the conversion rate to technology, whether you will be able to produce some technology out of it, because protecting a IP is very expensive. So you have to make sure whether I should protect or yes, it has come in my name, that is fine, that is okay. Those things, because I myself applied for 6 patents and 1 has been granted. Still 5 are in pipeline. Hopefully in 1 or 2 years it will be all will be granted. But I have to make sure whether I should protect or let it just be like that, okay, there is something like that. And if we have protected something and if it has a translational value, rather than protect it, is better to translate it. Go for a property protection. Even if not a patent, you can transfer this as a kind of license and do this, so that at least your thoughts, which are translated into products, those things has to be used in the field. So our patentable items should have short-term or long-term prospect for its application in the field or by the other stakeholders. Okay, I will not speak much time. I wish you all the best. There is plenty of time for your discussion. Whatever things you need to ask in the process of presentation, when Madam Dr. Rajneesh will present and Vidisha Madam is also coming, you note down all these things in your register and ask as much as possible. The good benefit is many times some people they avoid to ask, but the other ask, you get the benefit. That's why it should be a very highly interactive section where everybody will be good and all the programs will be recorded, so that even if you don't have to forget, you can just open the this thing YouTube and listen in. I will listen the entire program. So I wish you all the best for this program, and I wish from time to time whatever programs are being implemented in this center, in this institute, you keep a watch. Those who are interested, they can come and tell others to also participate. All my best wishes. Thank you so much.
Thank you, sir. Thank you for your blessing. Now I request Dr. Sushil sir for formal vote of thanks, sir. So please.
Good morning, Honorable Dr. A.K. Mohanty, Director of the Institute, Dr. Rajneesh K. Sharma, Attorney and Trustee, Ms. Chhavi Garg, IQ Officer, the Patent Office, and Sumit Mahajan, Organizing Secretary of this workshop. Scientists, senior scientists of this institute, dear students, it is a great moment that we are organizing such type of workshop third time or fourth time, and every time there is a great demand that again organize this type of workshop is very useful. On the demand of the students and faculty and others, this time we have organized it, and we have given an opportunity to take advantage by the online, offline. Offline we are having certain limitations, so we have called few, 30 or so, but rest others they have joined online. And they will also be recorded and it will be on the web, YouTube. So anytime you can go and you can visit, you can see these things and you can revise it and you can remember it, what are things. Nowadays, earlier we used to say that either publish or perish. Whatever you are doing it, you publish it, perish. Now it is again for more thing that don't publish and take the patent and get the benefit of these things. Because any sponsor who is sponsoring the project needs that he should get some patent along with some paper so that he can earn some money. So this is very useful and different aspect will be covered, and this will be you can take benefit. So I am thankful to the organizer as well as the management and principals of the different colleges who have sponsored their students, those who have come, and faculty also, those who have come here and those who have joined online. So I am also thankful to the organizer, along other co-organizers and our faculty and those who are involved directly or indirectly in organizing of this workshop. I hope this workshop will be very useful for the students and for everybody, faculty also, so they can get benefit of this thing. With this, I thank and hope that you will take some message, you will take some knowledge whenever you take and go to your home. With this, I thank you.
Thank you all for coming to this inaugural session. So with the permission of the chair, if we start with the schedule. Before starting with the schedule, sir, we are giving appraisal to the participants and all others about the technologies developed by our institute, sir. This is the device known as ICAR-CIRC ProLink CBP device for prevention of prepartum prolapse. This design has been registered with the Indian Patent Office, and this device is used for prevention of prolapse in animals, in cattle and buffaloes. As you all know that prolapse is a very big problem, and prevention is very much needed, because once the prolapse occurs, it will cause infertility and other problems in the animal. The other device which we have registered is ICAR-CIRC Pro UPT device. This is for management of uterine prolapse after it occurs. That one is for prevention and this one is for cure. This is CIRC cattle gland diagnostic kit. This is a RFLP based technique which has been developed for the genetic disease detection of cattle. This is a lamp assay which has been designed by this developed by this institute, and technology has been granted patent and recently, and it can detect 5% up to 5% level, minimum 5% level of cow milk meat mixed with buffalo. As you all know that this is legally required to, if there is any case or anything, so we have developed this kit. This is another kit which is a color-based assay for differentiating cow versus goat milk or meat. You all know that both legality and also in the recent time goat milk has been a precious item due to some research that it increases platelet count. So mixing is a big problem. So we can use this kit for detection of that. This is a cow cam assay kit. Again, this kit is used for detection of adulteration of cattle milk, cow milk in camel milk. As you know that camel milk has many medicinal properties. It has been proven that it can cure many diseases. So, if somebody mix that cow milk in a camel milk, it can be detected by this kit. This is a ICAR-C cattle CDM assay kit, and this kit is used for detection of genetic disease. And this is the most precious thing which this institute was established and developed by this institute. This is a Frieswald cattle. This breed has been registered, and we have also taken the trademark for this name. And this cattle breed has been developed by the longest running experiment in Indian history, or we can say a world history, with 56,000 lactation records and 18,000 animals with the Defense Ministry. And this breed has now been registered. Notification will likely be to become by Government of India. These are some of the technologies of ICAR-CIRC. Thank you very much, and now I will like to welcome ma'am for our presentation. Only presentation. Okay. WhatsApp is Gmail. Before I start, I will introduce Ms. Surbhi-ICAR ma'am. Ms. Surbhi-ICAR is a Gazetted A officer at Indian Patent Office. He is a patent examiner of patent and design. Ms. Shami is from Ahmedabad, working presently in Delhi. She passed out BTech in the year 2013. Over the past years, she has experience in both private and government sector. She has worked in Siemens Technologies and Services Bangalore for a few years, and then moved to Madhya Pradesh as a sub-divisional forest officer. And for past 5 years, she has been working with the Indian Patent Office. So she will be apprising you about the various patents, designs, and other things. I welcome you, ma'am, and I will just switch on to this.
Good morning, everyone. I'm Surbhi-ICAR. I am a Group A Gazetted Officer in Ministry of Commerce and Industry in the Indian Patent Office. Our office is in Delhi, Dwarka, and it's really an honor for me to come to this institute where all of you are scientists here, majority of you and others are aspiring to be. And it's really a good platform for the, where everybody should be aware about what are intellectual property rights. I just saw in the presentation the institute has done a lot of patent filing and even the trademark filing. So in today's session, my objective is that all of you here should know what is intellectual property, what are the different types of intellectual property that are granted by Government of India or registered by Government of India, and how do you do it? Okay, so these are the 3 primary objectives. And to begin the session, what is intellectual property? You must have heard a lot of definitions about it, but I am not going to those definitions because we are here for the practical approach. What is intellectual property rights? We hear human rights, we know what are human rights, right? But how many of you know what are intellectual property rights? Property, everybody knows property? घर, जमीन, property. English, Hindi, everybody comfortable? Okay. तो प्रॉपर्टी सब जाते हैं, घर, जमीन को प्रॉपर्टी बोलते हैं. इंडिया में क्या मानना है? As soon as you touch 30, घर वाले बोलते हैं शादी कर लो, घर खरीद लो, गाड़ी खरीद लो, then you're called settled in life. यही है? But 10 years from now, this is going to change. People are going to ask you, do you have an intellectual property in your name? Because that would be the real property. That will not have some monetary value per se attached to it, but will have an other means you can get benefit out of it. So, जो property के सामने हम एक word लगा देते हैं intellectual. It means that something that you make with your brain, with your knowledge, with your skill, with your education, what you make is the intellectual property. And the rights that are associated with those intellectual property are the intellectual property rights that you get when you have an intellectual property in your name that is duly granted or registered by Government of India. Okay? So, moving ahead, one simple example to make you understand how important are these intellectual properties would be in the coming decade. Laptop, everybody has worked with it. Okay. So this example will also tell you the different types of intellectual properties that are there, recognized in India. So, जब आप लैपटॉप बाहर से देखते हैं, एक HP का लैपटॉप और एक Apple के लैपटॉप की बॉडी अलग दिखती है, correct? How? HP laptop is little broader and an Apple laptop has a very slim look and it's a rectangular in shape, right? So this body of the laptop is the design intellectual property. It is one of the types of intellectual properties. Secondly, when you open your laptop, you type something, you do a video conference like people hearing today on the YouTube, they are not able to come. So they are hearing a conversation, a conference that is happening in Meerut through sitting in maybe any part of India. This is a technology. This technology is a patent. This is patent intellectual property. Thirdly, when I said the name HP or Apple laptop, जब आप लैपटॉप पे देखते हैं लोगो रहता है, करेक्ट? अभी जैसे आपको ICAR का बताया Frisball, they have already I think applied for the trademark. So this name of a company, name of a recognition of any product or any cattle breed is what is the trademark intellectual property. Okay? So Apple का लोगो कैसा है? Broken apple. Does it in any way signify an electronic product? No. But they got a trademark on it, and this is how we recognize the Apple product. जब आप लोगो देखते हैं तभी आप बोलेंगे ना Apple का फोन है, iPhone है, तब वो फोन नहीं iPhone हो जाता है, right? तो वो है trademark. Okay. The next thing is, if you would have ever opened the laptop, electronic students, if they would have been present here, they would have seen the motherboard and the chips that are there in the laptop. So the IC chips, how they are arranged, that is what is a semiconductor integrated circuit layout design. Okay, it is a type of intellectual property. So this is how, and the copyright. You get a manual with any electronic device that you buy, उसके ऊपर ऐसे C करके लिखा रहता है. Have you noticed that C on many products, even lot of books that you read, it has a C. So that is copyright. It is also a type of intellectual property. Moving ahead to the first session, patents. Okay, have you seen this? Cricket fans? Okay. So these are the LED beams. So पहले जब क्रिकेट में कोई आउट होता था क्रिकेटर, तो if there used to be some कोई डाउट होता तो थर्ड एम्पायर बताता था कि देख के कैमरे में रिवाइंड करके कि आउट है कि नहीं है. Now this Australian inventor what he did was LED सर्किट को उसने बेस में कनेक्ट कर दिया. ठीक है, in such a way that whenever the base rises from the stump they turn of red color, signifying that the cricketer is out. So this is a type of patent. Patent intellectual property. Okay. So I have kept this example to simplify the meaning of patent. People think that patent बहुत बड़ी चीज है कि सब लोग नहीं फाइल कर सकते, but it is not a big thing. It is a simple thing. Only the thing is you need to get your fundamentals correct कि किसको पेटेंट मिल सकता है और किस चीज को नहीं मिल सकता है. जैसे अभी हम प्रीवियस सेशन में सर कह रहे थे कि पेटेंट का प्रोसेस जो है बहुत एक्सपेंसिव है. करेक्ट. सो यू शुड नो कि कहाँ पे अपने पैसे लगाने हैं. राइट. सो थ्योरी की बात करें कि पेटेंट्स क्या है. पेटेंट इज समथिंग दैट इज गिवन टू अ प्रोडक्ट और टू अ प्रोसेस. ओके. प्रोडक्ट इज व्हाट? समथिंग दैट इज tangible, correct, which you can make a product. Process is what? To make that product you might have used some process, you can get a patent on that process also. Okay. Secondly, patent is a territorial right. What does this mean? If you have filed for a patent in India, your rights would be protected only in India. If you need to protect your patent in any other place, then sorry. I'm having a very bad throat, so bear with me. So, if you want to file a patent anywhere else, then you need to file separate applications at that place also. Okay. Patent is a monopolistic right. It means that if you get a patent, only you can use it. Nobody else can use it in your name. Okay. If they use it, they will have to give you royalty for it. Can anybody tell me what is royalty? Money. You can correlate royalty with the rent. If you have an apartment, you give it to somebody to rent it out to somebody, the person gives you money. In same way, when you have an intellectual property and somebody uses your property, then the person gives you royalty. Few examples of patent. The first photograph. It is a baby hat. So I am telling you how small a problem can be. Somebody identified this problem that जब बच्चों की आंख में शैम्पू जाता है, they cry a lot. So they invented a baby hat. This is a type of patent. It can be complex things like it can be a diagnostic kit to identify adulteration in milk. Products like that. It can be a drone to identify the agricultural soil area, like what are the nutrients that are needed. But it can be simple things also. So never hesitate to discuss that I have this idea, can a patent be given on it or not? What can be patented? So, as I said, patent can be given to a product or to a process, provided that it has the following characteristics. It should be new. Okay? It should have an inventive step. We will discuss these one by one. Capable of industrial application. Okay, so I'll discuss this one by one. What is new? New means we call it in Intellectual Property Act and the Patent Act as novelty. You must have heard this word, novelty. Okay. New means, for example, we'll go back to that LED based example. सबको समझ आया था? We'll go back there. So LED based was something new. अभी तक cricket में nobody has used LED based anywhere in the world. That is why it was new. Right? So it fulfilled the criteria of novelty. Next, inventive step. Okay? Inventive step का क्या मतलब है? ये सबसे crucial part है पेटेंट एक्ट का कि इनोवेटिव स्टेप को लोग समझ नहीं पाते. इनोवेटिव स्टेप का ये मतलब है जो भी प्रोडक्ट आपने बनाया या जो आपने प्रोसेस बनाया है उसमें टेक्निकल एडवांसमेंट है कि नहीं है. लाइक एलईडी बेस में टेक्निकल एडवांसमेंट था. अभी तक नॉर्मल बेस यूज हो रहे थे, अब उसमें एलईडी लाइट लगा दी, ऑटोमेट कर दिया उसके फंक्शन को, सो उसमें टेक्निकल एडवांसमेंट है. करेक्ट. सो पहला तो ये हो गया टेक्निकल एडवांसमेंट कंपेयर टू एग्जिस्टिंग नॉलेज. और हैविंग इकोनॉमिक सिग्निफिकेंस, देयर इज एन और बिटवीन. और मतलब दोनों में से कोई भी एक चीज भी चलेगा. सो इकोनॉमिक सिग्निफिकेंस है तो भी चलेगा, और बोथ. And that is an add there that makes the invention not obvious to the person skilled in the art. So people often argue, what is a person skilled in the art? A person skilled in the art is the one who understands the invention that you have made. If you are a biotech person, a person who is skilled in biotechnology, if he is able to deduce what you are claiming to be an invention, then it cannot be an invention. If it is already known to him. If जैसे मैथमेटिक्स में बोलते हैं ना a plus b is equal to c, suppose 7 plus 2 is equal to 9. This is obvious. You cannot say 7 plus 2 को मैं 10 कर रहा हूँ. How? You need to tell that. So there is a invention that is not obvious to a person skilled in that art. Thirdly, third criteria is industrial application. जैसे LED based थी, it has application in the industry, right? It can be made or used in the industry. It is being used in the cricket industry. So whenever ICC uses it in its matches, these LED bays, they pay a huge amount of royalty to the Australian person, or they buy his technology at one go and pay a huge amount of him as royalty. Okay, so this is how it works. पेटेंट की फाइलिंग का क्या प्रोसेस है? ओके, सो देयर आर 2 ways you can file a patent. It can be in online mode. This is the link that is given there. You can go there, create an account and go for filing of the patent application. Or you can go do an offline filing. We have offices in Delhi, Mumbai, Chennai and Kolkata at present. You can go to these offices and file for the offline application. Online application filing has 10% fees reduction, so I think you can avail that benefit. Forms क्या क्या required है patent filing के लिए? These are the basic forms. Form 1. Form 1 will have, I'll just tell these forms in brief. Form 1 will have the basic details about the inventor and the applicant. Your address, name, your patent agent, how many pages your application is, and all these basic details would be there in Form 1. Form 2. Form 2 is, I think you have a session planned with Form 2, that is drafting of the patent, in which I think they will deal with Form 2. But to give you a brief, Form 2 is the most important form, in which you need to mention your title of the invention, your field of the invention. Suppose you have done a file about LED base, you have to write the field of the invention. that it is relating to cricket. Then the background of the invention. What is the background from where you are deriving it? Okay. The drawings, brief description about the drawings. The drawings should be there. You should have an abstract that should be properly, made. And you should also have, the most important part, the claims. Okay. So I think claim drafting would also be dealt in the second session. So I'm not going to depth of it. And the third form that is there is Form 3. Form 3 is basically to know by the Indian government where all you have filed the invention, in which all countries you have filed. So if you have filed an application in US also, or it is a PCT application, you need to signify that in Form 3. Form 5 is basically the relationship between applicant and the inventor. So it will have the details about how the inventorship is decided. So that is Form 5. Form 18 is the most important one, and there is a lot of confusion regarding Form 18. People file Form 18 very late. I don't know why. But let me explain you about Form 18 when I go to the flow diagram. Why you need to file it early. These are the basic fees that are there. So if you are an individual applicant or you are filing by an educational institution, government has given a relaxation of 80%. 5,600 rupees will be required for filing of the patent. Whereas for like the companies that are filing, they are paying 28,000. So government itself is trying to make benefit for the students and educational institutions to go for filing. And also, this is how our portal looks like when you log in. And also one more important thing that the government has done is that I see a lot of female scientists here. So for them, if you are a female applicant, you can go for expedited examination process also by filing a different form and by reduced fees in it. So you can avail this benefit that is given to the female applicants. And talking about the process, as I told, I discussed Form 18 also here. So let me tell you from the beginning. Once you get an idea, okay, you get an idea what you have to do. As we were discussing, if you do not publish it, it will perish, right? So now the question is, how do we protect our intellectual property? Once you get an idea, you have to file it in the intellectual property office, the IP office, by either online or offline mode, as I discussed. Once you file it, okay, you can file two things. You can file either the provisional specification only, and in 12 months time you can go for filing of the complete specification. Okay. Now what is the difference between these two? Does anybody know provisional and complete specification difference? Provisional specification is something, when you have not drafted the claims, but you have a brief idea about your invention. So you define the broader scope of your invention, go for filing the basic idea without the claims. Then you will get 12 months time to draft your claims properly, define your scope properly, and go for filing of the complete specification. But the complete specification should not be outside the scope of the provisional specification. Okay? So in this 12 months when you file the complete specification, after that your application would be published. Okay? Once your application is published, okay. Now a request to examination is a Form 18. It has been amended right now from 48 to 31 months, just last Friday. So when you submit Form 18, okay, like I am examiner of patents and design. So whenever an applicant submits an application, the application will come to the examiner. Okay. So there are thousands of applications that are getting filed every day. Okay. How do I decide which one to examine first? So I follow a queue. Okay. And how the queue is formed? The queue is formed on the basis of Form 18. Suppose आज 18th March है, okay, and you have filed Form 18 today, okay, but your friend over there has filed Form 18 on 15th March. So I will examine that application will come into queue for me is that 15th March application मेरे पास पहले आएगी, then 18th March की आएगी, okay. So if you wait कि publication होने दो उसके बाद हम RQ file करेंगे, so that is a wrong approach. Your आपकी application जो है वो late examine होगी, आपको late patent मिलेगा. Then people ask the patent office में कि pendency क्यों है? Because we do not get the RQs. You have to file Form 18, then only it will come in our queue to examine. Okay? So you understand, as soon as you give the complete specification, there is no problem, you can go for filing of Form 18 by paying fees. Okay? So this was about Form 18. This 48 months timeline has been amended now. Then talking about when the application will come to me, I will examine the application on the basis of the 3 criteria that I said. What were the 3 criteria? Novelty, inventive step, industrial applicability. And formal examination is also there, whether you have filed all the forms that I have discussed before or not, or if there is some problem in filing of those forms. All those data, what I have examined, will come to you in FER, First Examination Report. Okay? So in this first examination report, how do you read this first examination report? Has anybody received a first examination report from the crowd here till now? You have received? You have received? Blue shirt. Okay. So how do you read this FER? So FER has 2 sections, broadly speaking. One section is the technical examination, in which we have examined novelty, inventive step, and industrial applicability. Thirdly, second section will have the formal. आपने कौन सा फॉर्म में क्या प्रॉब्लम है उसके बारे में है. So how do you read this FER? You read one objection at a time and try to see what the examiner is trying to tell you. Controller and examiner are trying to tell you, and make your reply accordingly. Once you get the FER, you have to give your reply within 6 months. Okay? If you do not give it in 6 months, your application would be abandoned. It will not be further examined. So how do you formulate a reply of your FER? It's very important, you know. What you can do is, I always say to people in the awareness sessions that make a tabular approach. Make a table. That is easier for everybody. Okay? What? If I have quoted D1 and D2 as the prior art of your invention for the application that you have filed, you can tell me D1 may this thing is not there, whereas in my claim this thing is there. Make a table. D2 may this thing is there, this thing is not there. So always go with a reply in a tabular form. Prefer doing it. I mean, it's not a format by the law, but it is a preferred way of doing it. So that we get to know clearly what you are trying to say. What is the unique thing in your invention. Okay? Then, after you file the response in 6 months, your application will come back to me. Okay? And I will re-examine your application on the basis of the reply that you have given. Okay? If you would have said me that XYZ component is new, I would go back to my D1 and D2 and check whether that XYZ is new or not. Okay, so it becomes is easier for us to, examine your applications if you form a tabular approach. Okay. Then after we re-examine, the controller will, issue you a hearing notice, wherein, you can have a video conference with the controller, or your agent can have a video conference with the controller and decide whether the patent can be granted or not. So this was the entire process of patent filing, and people ask like in which stage my application is there right now. So go to our website, that is INPASS, INPASS. Okay, when you search this on Google, you will get the internal database of patent in India. You can put on your application number and the captcha given there and find the status of your application. It is very simple. No need to, inquire here and there कि कितना दिन में patent मिलेगा. It is a time-taking process, but the situation is not better from past 10 years. So these are the basic timelines. Few timelines, as I told, have been amended just on Friday. So as I told, provisional to complete specification 12 months में file करना होता है, and request to examination is 31 months now. Reply to FER 6 months. These are the basic timelines. The second topic is designs. What is design intellectual property? First example, you remember HP and Apple laptop. So these bottles. Have you seen Coca-Cola और Pepsi की bottle? दोनों के shape different है. Have you ever noticed it? कि बस ले लेते हैं. Okay. So Coca-Cola and Pepsi की जो bottle है, उसके shape क्यों different है? इतना effort क्यों देना? Bottle designing पे. Because that is their brand. That is their brand. Okay, that is how the consumer recognizes them. Red color की broad bottle जो है, वो है Coca-Cola. Slimmer look की blue color की bottle है Pepsi. This is how you recognize it. Okay. So what is design? Design is the aesthetic appearance of any product. तो suppose आपने कोई device बनाई, okay? You made any device related to your field, okay? उसके design के लिए भी आप intellectual property apply कर सकते हैं, अगर वो design unique है, right? So this is what is the design intellectual property. So it can be designed for any 2D or 3D object. It can be a design for sari. It can be a design for the fan, the AC. हर एक कंपनी का डिजाइन अलग होता है because of this. It can be designed for any medicines. अगर pharma के, if anybody is from pharma related here, डोलो की टैबलेट बाकी कोई मल्टीविटामिन की टैबलेट से क्यों अलग दिखती है? This is the reason. Design. Okay. So this is how you recognize the product. कोई illiterate बंदा will not be able to read the name Dolo, but shape recognize कर सकता है. So this is that. In these cases, the design becomes important to find. If you are making a product जो illiterate लोगों तक भी reach कर रहा है, try to make a unique design. अगर आपने कोई see of course economic value, whether उसका design unique बनाने से आपको economically कुछ फायदा मिल रहा है, then only go for it. Criteria just in brief about design. जैसे पेटेंट में था novelty, नया होना चाहिए. Second thing, कहीं और publish नहीं होना चाहिए, ऐसा नहीं कहीं से cut copy paste कर दिया. Okay. Third thing is very important. Lot of people do not understand this. Significantly distinguishable. Your design should be significantly distinguishable. It means that, एक example देती हूँ basic सा. Monaco biscuit देखा है सबने? Circular biscuit, 3 या 4 उसमें ऐसे holes रहते हैं, correct? So if I start a biscuit factory and I say I make a biscuit which is circular and it is having 6 holes inside it, would I get the design on it? No, because it is not significantly distinguishable. तो सिग्निफिकेंटली डिस्टिंग्विशेबल का मतलब क्लियर हुआ? सो ऐसा नहीं कि आपने कोई एडिट्रेशन के लिए कोई डिवाइस बनाई है और आपके पास रेक्टेंगुलर है, उसमें 2 लाइटें हैं, ऐसा किसी डिवाइस में नहीं होता, तो ये डिजाइन यूनिक है। नो, ये लॉट ऑफ डिवाइसेस, बी इट अ मोडेम, राउटर, इसमें ऐसे लाइट जलती हैं। So you cannot get a design or something which is not, significantly distinguishable. और किस चीज पे डिजाइन नहीं मिल सकता? जैसे कि आप स्टैम्प पेपर, यू अंडरस्टैंड, स्टैम्प पेपर का डिजाइन नहीं बदल सकते, कोई एम्बलम, आई मीन नेशनल एम्बलम का डिजाइन आप नहीं बदल सकते। सो दीज थिंग्स आर नॉट। और जिसमें कमिंग टू ट्रेडमार्क, व्यापार चिन्ह बोलते हैं उसको हिंदी में। तो वी ऑल हैव वन नेम, राइट? आई एम छवि, यू माइट बी somebody else. How do you recognize that person? With the help of name, right? So now similarly any business or any name can be recognized when it has a name with it, right? Suppose I start a startup, तो उसका एक नाम होगा तभी तो लोग जानेंगे, करेक्ट? So something that identifies my business, that is what is a trademark. Okay? A trademark can be in various forms. पहली फोटोग्राफ आप देखो, it is a logo. Everybody would say here it is MACD का logo, correct? कोई भी मुझे ऐसा बोलेगा आपको this is letter M of English alphabet that is written in yellow color with red background. But anybody say this? No, because that company has done the publicity to make it feed into our brains कि M with red background जब दिखेगा तो McDonald's है, ठीक है? So this is how you create an impact on the consumer's mind by making a unique logo for your brand. जितना fanciful, arbitrary आपका लोगो होगा, उतना स्ट्रॉन्ग प्रोटेक्शन उसको मिलता है। ओके, सपोज जैसे कि आप ये टिक मार्क देखो, टिक मार्क नाइकी, it is anyway, does it anyway signify sports goods or sports shoes? No, so it is a very strong trademark. Okay, so this is when the person would register it, they would get a strong protection about it. So try to make your trademark more unique. Okay, trademark can be any slogan also. ये दिल मांगे मोर, it is a tagline of Pepsi. It can be, a website name also, naukri.com. Okay, it can be any word, name, symbol that I told that identifies the product. Okay, it is given for 10 years time and it can be renewed every 10 years. Now why it is given, we all understand. It is given so that your product or your business is duly recognized in the market. Now as I was saying, there is one more thing about trademark that I would like to say here. Like whenever आपने trademark के लिए apply किया होता है, you write TM on the top. जैसे अभी आपने देखा था स्लाइड में Frisk word. That is, I think it is not granted till now. That is why they have used the word TM on the top. When it would be granted by the Intellectual Property Office, you can use the letter R in a circle. Registered. It signifies that the trademark is registered. So you can always identify any good that you buy in the market. Why it is different? TM लिखा रहता है ना, मतलब that person has applied for the application in the Intellectual Property Office, and when it is R, the person has got the trademark registered. Okay? Copyrights. So copyrights is something, a very fascinating topic about copyrights is that copyright is a bundle of rights. What is a bundle of rights? एक एग्जाम्पल से बताती हूँ. You know about the author Chetan Bhagat? Yes. Okay. So what is a bundle of rights? when any author writes a novel, they can get a copyright on it, correct? अगर उस नॉवल के ऊपर कोई मूवी बनती है, कोई वेब सीरीज बनती है, then also the copyright is with the author. जो मूवी का प्रोड्यूसर है, that person has to take permission, pay royalty to the author, and then make movie or the web series. So it is a bundle of rights. Okay? So copyright is a very powerful right. Because once you get a copyright on something, you get the associated rights also. So copyright किस चीजों में मिलता है? Be it the literary work, we were talking about novels, be it any movie, any musical works, these are copyrights. Copyrights are given for different time duration. Like novel के case में you get it for 60 years past the life of the author. Life of the author plus 60 years. So in this way, different copyrights have different timelines. So just an interesting question. Just for your general knowledge, copyright movies का किसको मिलता है? Who get the copyright for a movie? Any movie? Actor? Actress? Anybody can answer? Producer, correct. So movie का copyright is with the producer. जब वो मूवी का पार्ट 2 बनता है और अगर वो कॉपीराइट वाले टाइम के अंदर ही है, तो पहले वाले प्रोड्यूसर से you have to pay the royalty to that other person also. Correct? So मूवी के केस में copyright lies with the producer. और जब हम मूवी देखने जाते हैं, we rarely look at the producer's name. Okay. So keep a note of the producer names next time you watch a movie. The next is the geographical indication. GI tag. ये बहुत बज़ वर्ड है, न्यूज में आपने बहुत बार सुना होगा. GI, ये प्रोडक्ट को GI मिल गया ऐसा करके. Have you heard? कौन से प्रोडक्ट के लिए सुना है? रसगुल्ला का जो लॉ कोड पैटर्न था, और एनी अदर प्रोडक्ट? बासमती राइस, करेक्ट. So coming to the theory of GI tag, GI tag किस प्रोडक्ट को मिलता है? जो कोई एक पर्टिकुलर ओरिजिन का हो, उसी एरिया में बनता हो, and it has a certain quality attached to it. Okay? GI जो है, for example, these are some of the GIs. केसर, कश्मीर की, you must have heard about it. Kashmiri saffron, Kathmandu of Rajasthan, these all are the GIs of India. There are more than 450 GIs at present. And why government of India is giving GIs? Why? So that वो जो community इन products को बना रही है, उनका economic development हो. I go to Mysore or I go to Kanchipuram, I will go and buy a sari from there. Why? Because Kanchipuram silk sarees have got the GI tag. So in that way, the person who is making these sarees would get the economic benefit of it. So in order to get the benefit of these, government of India is for the economic development of the community, we are trying to give the GI tag to give a proper platform to get the good rates for these products. The last topic is SICLD. So just in a brief, so that you should be aware about what there is something called this. Although it is not significant in your field, I think. What are the SICLD? Semiconductor integrated circuit layout design. Smartwatch. We all know smartwatches. So how a smartwatch, जैसे पहले घड़ी होती थी, बहुत बड़ी बड़ी घड़ी होती थी, अब हम उसको स्मार्ट वॉच की तरह इतनी छोटी सी घड़ी बना पा रहे हैं. How? Because of these IC chips. The placement of these IC chips, the layout, how these IC chips are placed, is what is the semiconductor integrated circuit layout design. And how, you might ask, it is different from the design. The difference is that these chips you cannot see with your naked eye, whereas the design is the aesthetic appearance, you can see it with your naked eye. So this is how the SICLD chips are there, and you can get the protection on these also. This is how the chips are designed there. These are magnified for better understanding. Coming to the conclusion, I've called the slide as IP everywhere. So some important takeaways which I would like you all to take from this session is that it is good to say that to publish, otherwise it will perish. But publication at the proper platform is important. Okay, do not publish anywhere else because if it is not a proper platform that is recognized by Government of India, then you might not get the patent on it. It will become prior knowledge. So publish in a proper platform. Okay, and when I say proper platform in the Gazette notification, some platforms are recognized by Government of India where if you publish, then उसके 12 महीने में भी अगर आप पेटेंट फाइल करते हैं तो आपको प्रोटेक्शन मिलेगा. But अगर कोई और प्लेटफॉर्म है which are not notified and you publish there, then you will not get the protection because आपका जो पेपर है वो prior knowledge बन जाएगा. Okay, it will disqualify under novelty criteria. Okay, so secondly, all these rights are territorial in nature. Territorial, remember I told, if you file in India, you will get protection only in India. For filing in other nations, we have different routes called as the PCT route or the conventional filing route, in which, just to give a brief, India has filed treaties with various nations, in which you can, go for filing in other nations in a very easy way. Then the registration or the granting of all these intellectual properties is done by our office only, that is Intellectual Property Office of Government of India, while no other state government, district organization can give you the certificate of this. So there are a lot of scams going on and people say that we can get you the certificate. Do not fall for it. It can only be given by Government of India. Okay. Next is, all the intellectual properties are given for limited time, except trademark that can be renewed every 10 years. There is no automatic release. लोग बहुत बार बोलते हैं कि मेरा ये पेटेंट है उसने कॉपी कर दिया तो गवर्नमेंट को एक्शन लेना चाहिए. तो गवर्नमेंट कैसे एक्शन लेगी जब तक पता ही नहीं है गवर्नमेंट को कि ऐसा कॉपी हुआ है, राइट? हमारे घर में चोरी होती है, वी गो एंड फाइल एफआईआर, राइट? सिमिलरली, अगर आपका पेटेंट या आपकी कोई इंटेलेक्चुअल प्रॉपर्टी इज बीइंग कॉपीराइटेड, इट्स बीइंग कॉपीड, बी द कॉपीराइट और पेटेंट, यू नीड टू फाइल अ कंप्लेंट फॉर इट फर्स्ट. देन रिन्यूअल फी का एक बहुत इंपॉर्टेंट कॉन्सेप्ट है कि आपको पेटेंट 20 इयर्स के लिए मिलता है, करेक्ट? But you have to pay a certain amount of renewal fee each year, starting from the second year onwards, at the end of the second year, so that your patent get renewed. तो अगर आपको पेटेंट मिला है, people often forget पेटेंट मिल गया, ठीक है, रख दिया. But check on the yearly fees that you have to pay. Otherwise, it will not be granted. Okay, so you have to check on the renewal fee also. Then the last one, as per the Patent Act, the requirement of patent agent is not mandatory, but you can avail the patent agent services for easy access and easy understanding of the process. Otherwise, you can also go for filing of the patent by yourself also in your name individually. Now, you can sign the documents by e-signature and submit them online with the help of your Aadhaar card. So that पहले क्राइटेरिया था कि ग्रुप भी आपको सिग्नेचर का क्राइटेरिया था, बट वो सब अब रिमूव कर दिया गया है. ओनली विद द हेल्प ऑफ योर आधार कार्ड यू कैन गो फॉर द filing of the patent, signing of those forms. So that would be all from my end. Now, any questions? I'll be happy to take.
Ma'am.
Yeah. Yeah.
Ma'am, as you have said that before filing, we have to pay the fees. In educational institution, you have said that you have to pay 5,800 something.
refunded by?
Your side. So the fees which we pay that time, it is refundable or not?
Okay. So her question for the online applicants, I would repeat, is that she has asked the question that if I file for the patent and I pay the fees, and if I don't get the patent, would the fees be refunded or not? So no, the fees will not be refunded because this fees is we are taking for examination process, and if your application is refused, it has been refused after duly examination and doing all the processes, so the fees will not be refunded. Any other questions? Do we have option to take questions from online app users? No. Okay. Again.
Ma'am, as you said that patent is territorial in nature, so if someone is filing a patent, then if that will, as a patent officer, will you be searching for it, or if it has been published in any other country or not?
Yes, that is what I said. Patent is territorial in nature in terms of protection of it, but not in terms of the novelty. Novelty would be searched everywhere across the world, whether it has been copied from somebody else or not. In US also, we would check. But the protection is given in India only, right? So there is a difference here, and I like to just elaborate on it. You may take the seat, please. See, just to make it clear to everybody, novelty का जो criteria मैंने बताया था, novelty किसी भी application की, कोई भी हम prior art search करते हैं, we check it across the database that checks across the world. अब ऐसा नहीं है कि आपने यूएस वाले की एप्लीकेशन लेके यहाँ इंडिया में कॉपी कर दिया, दिस विल नॉट बी ग्रांटेड अ पेटेंट. ओके, बट जब आपका प्रोटेक्शन मिलेगा वो इंडिया में मिल सकता है, बिकॉज हमारे पास जुरिस्डिक्शन केवल इंडिया का है, करेक्ट. बट अगर आपको यूएस में प्रोटेक्ट करना है अपना इन्वेंशन, आप यूएस में फाइल कर सकते हैं सेपरेटली, एंड द यूएस पीपल यू कैन टेक द प्रायोरिटी ऑफ इंडियन एप्लीकेशन एंड गो फॉर फाइलिंग ऑफ यूएस एप्लीकेशन इन यूएस or in any other nation for matter. Okay? Yeah. Okay. No more questions? Okay. Thank you everyone for being so, for my bad throat also you guys cooperated. So thank you everyone.
Thank you, ma'am. Thank you for your presentation. Now I request all the participants, they can have a tea break below. They can go and have a tea, and within 15 minutes you will be coming back. Okay? Disha ma'am will be taking lecture.
आप मेरे सर थोड़ा
पॉज का ऑप्शन है क्या? स्टॉप स्ट्रीमिंग